Good morning, and thank you very much for joining us. I am Yori Folarin. I guess we'll pick up this morning where we sort of left off last week, because last week we were in Abia, and the situation hasn't abated. It looks like there's still a lot of meat on that bone, according to the political terrain in Abia State. This morning, the High Court in Abuja will be listening to the whole matter of a stay of application plea by the incumbent governor Ikpeazu. And as you will recall, in Abia, Oga has been given, Uche Oga, Mr. Uche Oga has been given a certificate of returns. And so there are those who are saying that there are two certificates of returns now, even though when we talked about it last week, we speculated that, well, if INEC had issued this, certificate of returns to Mr. Oga, then it automatically had nullified the last one. But Ikpeazu is still very much on the matter. And you might have seen the papers yesterday talking about fighting dirty. Now they're calling themselves names. And but that's not really what concerns us too much as to where we are legally. Where's the chief judge, for instance? You can't swear in a new governor without a chief judge. Nobody has seen very, very much of the chief judge of Abia State. To help us try and make sense out of all of this, we've got our friend in the house, Barrister Chukwuemeka Eze. He keeps a tab on all of these things. Morning, Emeka. Great to have you with us.
Thank you.
This morning, there are all sorts of sands. It's raining sands in this kind of a matter. Barrister Paul Ananaba, SAN, he, I understand, was the lead counsel in the matter for Uche Oga. But this morning, I understand it's Barrister Ikpeazu, but it's Awomolo, I understand.
Yes, I think the matter will be heard this morning. The last time I read that Adegboyega Awomolo filed the notice of appeal and the application for stay of execution.
Yes.
So basically, whoever filed it, the principles of law remain the same, and they are tried principles of law.
So what this means then, because on Friday when we were talking, we had two lawyers too, there was this whole conversation over whether or not a notice of appeal had been given, and that you can't do without that.
That has been resolved. INEC has acknowledged receiving the notice of appeal and the application for stay of execution of the judgment of the Federal High Court.
So technically, we now have two.
Justice Okonaban.
Yes, okay. We now have two, as it were, certificates of returns.
Sure. And INEC, I think, has caused the confusion because you don't need to be a son to know that as a lawyer, when you get a judgment and your opponent files a notice of appeal and an application for stay of execution, all the parties will maintain the status quo until that application is argued in court. In fact, almost all lawyers who are practicing have cases they have won in court for which they have been unable to execute because their opponents filed one application or the other, even without waiting for a judgment or a ruling to be given to the application for stay of execution. That is what I know in practice, and I challenge any lawyer who will challenge me on this principle that when a judgment is gotten, I know it is tried principle of law that a party is entitled to enjoy the fruits of his judgment. But like every general rule, there are exceptions. Some lawyers argue based on general rule. In logic, you have a general rule, you ask yourself, what of the exceptions? I give you an instance.
Okay.
Human beings, you have men, you have women. But there are human beings in between called is it Aphrodite or hermaphrodites? So these people, there are human beings that have both reproductive organs of men and those of women. So in law, I hardly see any general rule that does not have exceptions, although a notice of appeal does not operate as a stay of execution.
Okay.
In theory, rules of course contain it. But in practice, what happens is that when you get a judgment and you get a certified true copy of the judgment, you serve it on your opponent. That judge who gave the judgment will still be expected to sign writ of execution. And before he signs the writ of execution, the file will be brought to him. He will mean it to the relevant administrative section to find out the registrar whether any application has been filed in respect of this matter. If the answer is yes, he will not be hasty in giving his signature. He will most likely wait to find out the purport of that application. And no matter how frivolous, he will likely hear the application before putting down his signature. So INEC, ask yourself, this is not the first time we are having this situation. Remember in Ngige's time, Egbegbo gave a judgment and they wanted to carry it out instantly on Ngige. The whole Nigeria cried out that he has a right of appeal, wait for the appeal. And it was when Ngige lost his appeal that Ngige was booted out. Though exactly not in that case, but yes, in another case. And you recall that Enugu High Court had granted an order at the time that I think Enugu High Court, Ngige, former Governor Ngige, should, they presented a document, they said he had signed, he had resigned from his office, even an AIG went to arrest him and all that. You recall that these were court judgments. At that time, I wrote in one of the national dailies on the breach that the authorities wanted to commit. And many Nigerians voiced their opinions in favor of Ngige. Not because Ngige was right, not because Ngige had won the election or didn't go to Okija. All the facts were in the public domain. And even there was a judgment against Ngige. But when the government wanted to effect that judgment, Nigerians cried out, and Ngige was left to be, pending when the appeal was determined. So when we speak, we forget to ask ourselves, where are we coming from? Is
because
this the first time somebody...
precedents.
Yes.
Similar.
Is this the first time somebody had gotten a judgment and the authorities, including INEC, waited for the Court of Appeal and the Supreme Court in appropriate cases to decide? If journalists can go into the archives, they will find avalanche of statements made by INEC where people at the Court of First Instance wanted INEC to implement the judgment, and INEC say we can't do so. We are waiting for the appellate court to take a decision. It's because we don't dive into these things.
And the implication of that is that, of course, and this was the case in Governor Ikpeazu's situation, you've got to file an appeal. If you don't file, then that's a different matter.
That's
a different matter.
In fact, if INEC had not received the notice of appeal on Thursday when it gave the certificate of returns, INEC would have been in order. Because INEC will not wait for you until when you have decided to appeal. Because the order said immediately. It was given on Monday. Why is it that INEC did not issue the certificate of return on that Monday? Were they not waiting for the CTC?
Yes.
Good. Were they not waiting for the writ of execution? They waited for something.
Yes.
And that means they could have also waited for another thing.
Is there a limitation, a statute of limitation? Is it hours, is it days or weeks after a judgment such as Oga got for you to serve notice of appeal to indicate that you're going to be appealing?
No, definitely it's been a final judgment.
Okay.
They had definitely had at least a month to appeal that. Okay. But that is not the issue here. No lawyer is arguing on that one. The issue is, did Ikpeazu file a notice of appeal? The answer is yes.
Apparently yes.
Did he serve it on INEC? The answer is yes. Did he file an application for stay of execution? The answer is yes. Did he serve it on INEC before the issuance of the certificate? The answer is yes.
Is the answer yes there?
Yes.
It isn't cloudy. It isn't cloudy whether he served it on INEC.
No, INEC has acknowledged it.
I know, but why then, in your opinion, Did INEC go ahead and issue a
It
certificate
is
of
only
returns?
INEC, the legal department of INEC that can answer the question. Because the law, if you allow an anarchic situation in your attempt to implement the law, you will find what you are finding now. And if we continue this way, definitely lives will be lost. And you don't intend to apply the law in such a way to get lives lost. Why not make haste slowly? Since you know that if the Court of Appeal decides this matter in Uche Oga's favor, definitely Uche Oga will be the governor of Abia State. Take sentiments out of it. Sentimentally, many of us morally prefer Uche Oga. But if we are talking of laws, I speak with you. I have many judgments that the court, the sheriff section, has refused to execute just because the other council filed a frivolous application. The application might be so frivolous, immediately they see the sheriff section sees it, they will refuse to execute. So ask yourself, why this turnaround? Why this exception? INEC does not have a history of implementing decisions of courts of first instance, unless the other party has not filed any appeal. I want to be quoted wrongly. Give me a case where INEC has implemented this type of judgment. Just give me one case. INEC didn't start today. Since 1998.
So you as a practicing lawyer, you can't immediately think of a precedent in this regard?
I cannot. And I want to be told where the other party served them and INEC ignored it and issued a certificate of return. I want to
because
learn.
That's what you think, because that's what you think happened in this situation.
That's not what I think, because except if the reports in the papers are wrong, INEC has acknowledged receiving them. I'm not speculating.
And the time also is not in doubt. It is not before INEC issued the certificate of returns or after.
On Thursday. INEC issued on Thursday. The order was given on Monday. And the service was done before the issuance. And you ask yourself, is it easy in this country? If you get something, I want you to appreciate, Yori, that immediately the certificate was issued, both police, all the people that should travel with, they were already on a chartered plane to my. Our system don't work so fast.
Okay, tell you what, Mr. Okorafor is calling in from Arochukwu. Good morning, Mr. Okorafor.
Good morning, sir.
Go ahead, please.
Yeah, honestly, I thank all Nigerians. I'm just praying. In my state, Abia State now, I just pray to the youth. Let us think forward. Because when I'm saying let us think forward in our state, is that we as Abians, God's own state people, if we destroy our state because of our own individualistic behavior or individualistic ideology, it will not help us. Because if you come to Abia State today, people from Arochukwu to Hofia, our roads, we cannot run. And I thank our boys, men and women that in Lagos State. And I thank the Lagos people, they have tried. For them to pick up that project, say they will come to Arochukwu and use their money into call Aro to do that road, which is a federal government route. After the Civil War ended as far back as 1970. Nobody has visited that road to make sure that people there see the day of the life. So I'm calling on all those boys in Lagos. May God bless them that at least for opening their mouth, say they are coming to repair that road. Now the question is this. In Abia State, as we are all seeing what is happening there now, it is not the job of one person. And I've seen of people that say, let us wait for the appeal court, from appeal court to Supreme Court. Let us see the reality of our judiciary. Because for everybody to put hand inside the pocket and say, we want this, we want it. Destroying the place will not solve our problem. Because teachers are complaining, they have not been paid. Pensioners have been complaining, they have not been paid. By next week now, students will go on holiday. You see many of them roaming about the streets. And then the market is there. Market, rain every day. Nobody say, what do we do? It is only peace and conducive environment that make everything move forward. Thank you very much, Comrade Mazi. Patrick Okoro Krapo of Arochukwu is my name. Thank you, Okowo Blue Village.
Thank you, Mazi. Thank you very much for calling in, Mazi. Interesting. And by the way, well, we got in touch with Paul Ananaba, SAN, lead counsel, I believe, for Governor Ukpeazu. But today being what it is, they'll be hearing the matter in Abuja with, you know, Adeboga Womola SAN presenting. He probably is going to be there as well. He, however, did assure us when we got in touch with him that he'd see what he could do to sending in a representative. And so we're still hopeful that Paul Ananaba's representative will indeed show on the program, because it will be good to shed some light on the matter. Now, the substantive issue that lawyers are probably dealing with, the whole almost foundation of this whole legal tussle and controversy, is that Governor Ikpeazu allegedly was not even fit and proper to be presented for even the primaries, having, well, the way it was phrased was that forged his certificate or tax returns, certificate of tax returns. So that is something. What part is this going to play in all of it? Because that seemed to be the technical point. That even, by the way, when we go back and look at it, this man shouldn't have been on the primaries. Lawyers before you who looked at this issue were at pains to distinguish between pre-election matters and post-election matters.
I think we should draw ourselves away from that right now, because the controversy between pre-election matters and post-election matters will not help in this circumstance and has not brought us to where we are, except we want to be theoretical.
Okay, one moment, please. At that point, let me just interrupt you briefly, and forgive me for doing so. I've got to bring in Mr. Dedei, who also is calling in from Surulere, I believe. Good morning, Mr. Dedei. Ikeja. Okay, you're in Ikeja, not Surulere. Good morning.
Good morning, sir. Good morning to the guests.
Good morning.
I have always known that a situation like this will arise one day when the judiciary will be boxed into a corner, you know, because the judiciary has been, since the advent of this democracy, they have been underperforming. And quite unfortunately, I think they have been grossly politicized and corrupted. Now, look at the way they have been shopping for court judgments here and there. One will go to the same court of coordinate jurisdiction to get injunction. You know, they are going, all sorts of terrible things happening. Now, in the case of this Abia, whatever comment you get depends on maybe the sentiment of lawyers, because I have listened to a lot of senior advocates, and all of them have been giving contrasting views on this matter, contrasting views entirely. While some will say that Section 142, which talks about the Election Petition Tribunal, to also hold in this case. Some will say that it does not hold on this case because it's a pre-election matter. You know, so what do we believe?
Yeah.
Where exactly do we go?
Yeah.
Now, sir, please hold on a minute. Now, in this matter, now it is not about sentiment. It is what does the law really say? The court has said that this man should be sworn in immediately. The INEC said that they received a notice of appeal, but they did not receive a notice of stay of execution. And lawyers have said that if a notice of appeal on this ground does not serve as a stay of execution, so why don't they swear in the first one, since the court has already ordered that the man should be sworn in immediately, and let the man go to court to prove his case?
Yes. Okay. Thank you very much. Thank you very much, Mr. Dede. Really appreciate your call. Emeka, that's a fine point to come to, because the point was also made by some lawyers that a notice of appeal does not act as a stay of execution. And
I still make the same point, because it is contained in the rules of court. It's contained in the laws of, in the practice of court. But I'm telling you, it's a general rule that it has exceptions.
Okay.
And INEC never said it did not receive application for stay of execution. INEC said, according to the report I read, except if the report is wrong. INEC said it did not receive order for stay. Not that it did not receive application for stay. But I'm telling you with all honesty and honor, not based on sentiment, that when you receive application for stay of execution, the status quo will be maintained, even before getting the order. And I have said, whatever any lawyer has said, they should cite for me just a case where INEC received a stay, application for stay, received a notice of appeal within 3 days of giving an order, and he proceeded to issue certificate of return.
It hasn't happened before.
It hasn't happened before now, and it has been having many cases of this nature. It had never acted this way. That's one. Two, you're talking about a pre-election, and now matters that appertain to a case prior to election, pre-election, from the name. And if it arose from the conduct of election in any way, it will go to election tribunal. This one did not go to election tribunal. It was decided at the Federal High Court. But it has the same force when there is a judgment. The issue is there is a judgment. We should not do the analysis of the judgment because an appellate court will still decide on it. We are talking of procedure.
Okay.
And it is not the judiciary that has caused this problem. It's INEC.
Okay, one moment, please. Yakub, thank you for holding on. Go right ahead, please.
Yeah, thank you, Chief Yorin. This is Yakub from Dr. Muta. And then good morning to your guest.
Good morning.
Yeah, sir, Chief Yorin, with due respect to your guest this morning, I dare to disagree with him for some certain reasons. He says that our system does not work the way it is now. I want to ask you a question, sir. Chief Yorin, I think we are in the change era. It does not mean that when the system is not working before, it will never work. Why am I saying that? The court gives an order that this money should be signed immediately. The word of immediately, I don't know, maybe it still means another thing. Immediately, to my own personal opinion, as a layman Nigerian, immediately means immediate effect. So if court say you should sign this guy immediately, doesn't mean that INEC should, I don't run for issue the certificate of return to the person that goes to the court. For my own personal opinion, that's all right. And if their system is not working yesterday, I dare to disagree with the lawyer. Though I really respect his opinion some certain time, because this is not the first time he appeared in the studio. I always respect his, but this one I disagree. If it does not work yesterday, it does not mean it should not work forever. We have to change. And then this is the Mr. President says that it is for everybody, it is for nobody. If it is before, you can see in the present era, they will just give order that this thing should still stay. Are you getting it now? Another from the High Court, from the Federal High Court, and then another from the state. Our judiciary should be able to work hand to hand because a Federal High Court gives an order, a state High Court gives another order. What is that?
All right then. Okay, thank you very much,
Yeah,
Yakub.
we should correct an impression.
Sure. Which one?
The impression we need to correct is that when there is a law, it has to be amended for it to change. It will not change because of a mantra of somebody in power. So Nigerians should note that whereas in the executive segment of our democracy, the president can just say something and it begins to happen. When it has to do with the laws of the country, the best you can do is to ensure that the legislature amends the law to bring about that change. So the law has not been amended.
Okay. The point you made about the judgment including the word immediately.
The word immediately has not changed. See, every judgment will mean what it says. The fact that the other party will wait for the application, okay, let us discuss it now from his own angle.
No.
From his own angle.
Well, remember his angle so that I can come back to it, because in the meantime, Samuel has called in from Lekki. Good morning, Samuel.
Yeah, good morning, Mr. Yoris, and good morning, the guest.
Thank you.
Yes, I just want to throw the line on the last caller. Are we supposed to be doing things the same way and expecting the different report results? How can we expect something that is wrong? We keep on doing something wrong and you want it to stand. When you see in developed countries, somebody like that governor would have resigned and would have been arrested. You presented a false start clearance, and you still want to remain there as the governor. So this people, thank you. I have a wonderful day.
All right, then. Thank you very much. It's a very, very interesting case. On the one hand, if you saw yesterday's front page in The Nation, on the one hand, Governor Ikpeazu was talking about the desperation, and he was saying that Oga has so many different criminal cases to answer to in court, and Oga replies that he has nothing to fear and that the sitting governor should just tell people why he was dismissed from the university as a lecturer. So you can see that they've really gone dirty. But
I'm interested in the legal angle.
Exactly.
Because politicians can come and discuss the political angle.
Okay.
And I just want to enlighten us that this is not we are not doing voting. We should think of what the law says before anybody takes a definitive position. The person should go and read the law on the subject, read decided cases, read cases like Shell Petroleum Development Corporation of Nigeria and Amadi, 14 Nigeria Weekly Law Report, part 1266, page 157, particularly at page 190. You don't foist a fait accompli on the appellate court. So this is not a matter of take it to the marketplace, appeal to the sentiments of people, and we begin to vote. People will come and discuss that angle. I'm interested in discussing the Lego qua Lego.
Okay.
And the fact that lawyers have different opinions, it is right. Why is law in the Faculty of Humanities, in the universities? It is in a faculty where differing opinions are accommodated.
Yeah, but,
and the Romans have already encapsulated it.
Yeah, but the point, Emeka, is that all of what you've just said, this will be music to the ears of lawyers. The rest of us, we just look to the courts that these arguments would have been presented before a judge. The judge will then pronounce, and then we will say, this is what the court says, and this is the next course of action. But you see that we have a very mixed bag. On the one hand, the chief judge of Abia State suddenly, I don't know whether the man is in protective custody or whatever.
The woman has clarified, that she was in court.
So the judge is actually not at large.
She's not at large.
Okay, I got to go on a break now.
If the report is right.
Yes.
Because I wasn't there.
Yes.
If the report.
Okay, we'll come back and continue, but we'll go on a short break. Don't go anywhere, please. We'll continue taking your calls. Okay, welcome back. Still looking at the whole election appeal saga in Abia State. And, trying to, that is Uche Oga trying to unseat through the courts, Governor Okezie, Ikpeazu, and, Ikpeazu is not taking it lying down. And so we're still in the middle of it. And as we speak in Abuja, a court will be deciding on the whole matter of a stay of execution. But one of the more interesting facts last week was that the CJ, the Chief Judge of Abia State, Justice Teresa Uzokwe, she was reported, not everybody knew her name at the time, but she was just going by Chief Judge, was reported to be not available. But stuff has still since come out that indeed the chief judge actually was in court, and she's not been inaccessible or unavailable. So the intrigue deepens, sort of, and so this, I suppose, you can expect when politics meets the law.
Sure.
When politics meets the law. Of politics and law. So all of it, because among the questions we asked on, I think it was last week, was it Friday when we looked at it, was that, look, if this judgment has come out, and as Yakub said from Dr. Mujos there, the word immediately was in it, why wouldn't the Inspector General of Police swing into action immediately as an upholder of the law and cause the whole judgment to take effect?
The answer is simple. The word immediately is elastic. The word immediately does not mean 1 minute. It does not mean 1 hour. It does not mean 1 day. It does not mean 1 week. It comes within any of those times.
Immediately, to the layman means instantly.
Okay, now.
It means instantly.
No, when a word is elastic, it means even if it happens within 2 weeks, it's still immediately.
And that's not immediately.
No, let me.
In law.
No, let me.
Immediately can be 2 weeks in law.
Let me tell you, even in English, if we use immediate, you ask yourself, words are used within context. Okay, will you apply immediately without waiting for the certified true copy of the judgment? No, I'm asking you because you are now using immediately.
No,
immediately I'm telling you, the judge that gave the order knows that certain things will happen before immediately.
Of course.
Will be
immediately. Of course.
Good. And I'm telling you that immediately, we have not exceeded it.
Okay. Because all the conditions have not been perfected for immediately.
We are still within the immediately.
For the legal implication of immediately
some
to take effect.
people think immediately is, okay, maybe the minute after the judge sat, the next minute became immediately.
Yes.
Then what time did the registrar type the judgment of the court? What time did the CTC obtained? What time did they send it to the appropriate department to prepare for execution? What time did they send it to INEC and all other authorities, parties that partook in that case? Why, if it were immediately, why did they waste time doing all those things? Immediately the judge rose, they should have just catapulted.
Well, immediately, I understand, but immediately will have to be within reasonable
in any case, we should
duration.
Not confuse the public.
Yes.
In law, whatever word you use in a judgment, once a notice of appeal coupled with an application for stay of execution is served on the winning party,
then there's effectively
the
status quo remains.
Maintained.
Okay, thank you very much for holding on all that while. Ehis from Magodo, good morning.
Good morning, Mr. Ayari. You kept me for more than 4 minutes.
4 minutes, I'm so sorry. This is what these lawyers do.
To your guest. I would just want to say, Nigerians, we should learn when to draw between sentiments and analyzing issues. Like what your guests have said so far. I'm not a lawyer. He is a lawyer. And the thing just baffles me when people who are not lawyers, even when we are educated, when it comes to issues that concern law, I think we should also listen to those who are lawyers. That is why we say they are learning. Like my friend Yakubu, who I love, is most time when he calls so much, he said something. He has also forgotten that in this same era of change, a lawmaker from Benue State got a judgment against a fellow lawmaker. If you remember the case of that sole lawmaker who was not having a contender during that last election, who is in the House of Reps, where another lawmaker went to court and said he was having certificate issues and he was removed, and somebody else took over his seat. A high court gave a judgment saying that cannot stand, that he should be sworn in. Are you aware? Because of the appeal, the man in the House of Reps fined. Without even stay of education on that appeal, he was fined. Do you know, as I speak to you now, he's still in the House of Reps. Why that case is now, the appeal is filed to Supreme Court. Did anybody remove me from office? Did INEC issue certificate because it's the era of change? It's also unfortunately the kind of system we run. And when you look at the way the INEC person, I'm not going to accuse INEC. I'm going to talk about the man in question who issued that certificate. When you look at his body language, the way he was talking, that I don't want to go to prison, you understand that there is more than we don't know to what is going on.
All right. All right. Thank you very, very much, Ehis. And again, apologies for keeping you for 4 minutes. That shouldn't be. But the crisis is raging. We also had thought when we were talking about it last week that, you know what, the Attorney General of the Federation should just step into this whole matter. But the Attorney General seems to be erring on the side of caution, if indeed erring is what he is doing. He says, one of the papers this morning, The Punch says, Ikpeazu Oga should wait for courts to decide cases, says Minister. I guess, and then the CJ has said that, the Chief Judge has said, I'm not on the run in any way, shape or form. But coming back to this whole matter of the body of the case, as Yakub said, is it Yakub or someone else that he's listening? No, it wasn't Yakub. It was the other gentleman from Ikeja that he's heard so many lawyers, SANs for that matter, giving, let me not say contradictory, but contrasting opinions on this matter. Well, thank God for judges. That's what judges are supposed to resolve. All these contrasting arguments will be put before them. They will then use the body of the law to say, now, this is the pronouncement of this court. And then everybody has to run with it, whether you like it or not, once we have exhausted all the matters of appeal. But we're a far way from that right now in terms of exhausting. So is the best position really one of, let's just stay for the moment, and this matter has not been resolved, contrary to what Mr. Oga and his legal team might want?
Thank you, Yori. I just want to observe with...
Adewale has been holding on from Alagbole. I'm so sorry. Let me take Mr. Adewale. Good morning, Mr. Adewale.
Yeah, good morning, Mr. Yori.
Thank you for calling in, sir.
And also good morning to your guest.
Thank you, sir.
I just want to add something to the discussion going on.
Sure.
Actually, I'm the first caller because I've been trying all the lines.
Well, thank God you got in today. We're great. It's great to have you.
Yeah, I'm happy as well. This issue that we are talking, I'm worried. And the reason why I'm worried is that this, our man called Oga and the INEC Bulala, I don't know why they will be so hasty to execute the judgment when they know that the justice is so fair to all parties. Fine. If you know you have a case and your case is valid, you're supposed to allow the other man to also respond, whether he will accept that thing and give you the chance to, take over, or he will also appeal. Because in all this situation, there is a provision that this man also can also pursue it to Supreme Court. We have not got it to Supreme Court, and all of you are rushing.
All right then, Mr. Adewale, thank you very much. We get the point you're making. In fact, it is the very principle that we wanted to talk about before your call came in, so it has really helped the situation. As I was saying, and it's implied in what Mr. Adewale was saying, we're a far way away from a complete resolution of the case, since the Supreme Court is still a possibility.
Sure. The issue of contrasting views by lawyers, it should be expected. The Romans had earlier said it long ago. Roman law influenced the common law which we learned in the schools and all that. Now, it said, quod homines tot sententia. When interpreted in English, as there are different human beings, so there are varied opinions. So don't get worried when there are varied opinions. Even when matches are being played, you see fans, some supporting Chelsea, some supporting Liverpool and all that. So even a particular team, if you get fans, they will be having varied opinions on how Ronaldo is playing. Some will say he's playing well, some will say he's not playing well. But whichever way, the thing is this thing does not require voting. It's not an election thing. I mean, in terms of taking a position as a professional.
It's an application of the law.
I'm discussing this matter as a professional.
Okay. Not on one side or the other.
No. Even if you interpret it one side, whichever way. But I have decided to discuss it purely as a professional.
Okay.
Not from political point of view of anybody.
Let me hear it from Mazi calling in from Iju. Good morning, Mazi.
Yeah, good morning, Mr. How are you? Mazi Obioha is my name.
Mazi?
Obioha.
Mazi Obioha. Good morning.
Yes. So how are you today? Good morning to our guest.
Go ahead, please.
I have to come from the same area with Bazo.
Okay.
Anangwa man.
Okay.
From Alangwa North and he's from Obingo. We are not happy with what is happening in other states right now. I don't know the hasty. Why I make rush in giving out certificate of a result. Where there are opportunities. The law did not say this man should not go to Supreme Court or Court of Appeal. There are windows. The Court of Appeal and Supreme Court is there. Why the hasty? Which means there are more to be told that make the INEC officer to issue the certificate without further delay. I mean, it's crazy. It's crazy. And they wanted to enforce the swearing in of the Oga, which is not good. They should allow. I am from Abia, and I don't want a wrong thing to be done. I don't support evil. If okay, at the end of it, lose it either than the Court of Appeal or Supreme Court, to God be the glory. If he is actually found guilty of forgery, he should go for it. But there should be room for him to exercise his parliamentary rights. God bless you.
Thank you very much, Mazi Obioha.
I was speaking on it.
Yes.
Every right is subject to another right, Yori. For those talking about English meaning of immediately, there is no right that is not subject. No right is absolute. So the right to apply immediately is subject to the other party's right to appeal. So there's a balancing act. You balance the judgment, you balance the effort to fight the judgment.
That's fine.
And you don't foist a fait accompli. You don't take a step that will render the subsequent decision of the Court of Appeal nugatory.
Yeah.
If he did not appeal and file an application for stay of execution, this argument would have become totally unnecessary.
Okay. Taufik calling in from Oshogbo. Good morning, sir.
Good morning, Mr. Lori.
Thank you for calling in.
And good morning to the mayor in the house.
Good morning. Thank you.
So mine is a form of a question I want to ask. INEC, do they have right to just issue a certificate without them having acknowledgement from the High Court for the ruling? That's one. Then second, if such is not in place, maybe for them, if they just had the announcement from the court, they had the right to go ahead. But thirdly, please, if there is none of this, why can't the legal practitioners stand on INEC for making them to look so irresponsible? And I have a point again, like what happened with the PDP, whereby High Court in Port Harcourt was saying McCarthy is the body chairperson, another one in Lagos was saying the Sheriff, the same High Court. Please, I think the legal practitioner should look into this. It looks so ugly for Nigerian judiciary.
All right, then. Thank you very much for calling. This is laymen will probably just want to be grabbing at the real kernel, and I think this whole thing is based on an accusation of forgery against the sitting governor. Now, if that is proven, the whole thing falls apart. If, and it's a big if, capital I, capital F.
That is the issue for the Court of Appeal.
Okay.
It's not an issue for any lawyer to sit in any media house to begin to talk about the substance. That is the substantive matter, and lawyers have been warned. You are not in a case, you just read in newspapers, you come to a media house and open your mouth and begin to condemn one party or condemn the other party. I'm not interested
in... No, but I beg your pardon.
Yes.
The judgment that was given in favor of Oga was based on this whole charge that the sitting governor actually forged his, document.
No, I don't think that issue of forgery or...
because he would therefore be ineligible. He will be ineligible given the provisions of his party's...
It was gotten on a Saturday. They said it was gotten on a Saturday.
That is the certificate of the tax clearance.
So, but I'm saying whatever may be the substance, it will be an act of indiscretion for any lawyer to begin to do the analysis of the substance.
Because that's the job of the judge.
Yes, and which is about going to the Court of Appeal. It's sub judice. If there is no appeal on it, or we are doing appurtenance analysis, things around it, just as we are doing, whether this person was right in issuing certificate of return, we are not discussing the judgment. We are discussing matters appurtenant to the judgment, and we have a right to do so. But issue of forgery, non-forgery, leave it for the Court of Appeal, be patient. Nobody knows. In fact, it is a possibility that Uchoga will succeed at the Court of Appeal. The only issue is the way we have been practicing law all over the ages is that once you file a notice of appeal and file an application for stay of execution within time before the execution. If you do it after the execution, it's of no event.
Okay, let's hear it from Mahmoud. Mr. Mahmoud calling in from Ikoyi. Good morning.
Good morning, Mr. Yore.
Thank you for calling, sir.
And thanks for the good job you are doing for Nigeria.
Very kind of you.
And your lawyer also there, he's a very nice lawyer. He has always been helping we Nigerians, educating us. You see, this is a Abia problem. I just feel, I think the whole thing to me, I'm not a lawyer. It's too much. The whole matter is too much. It's a rush matter. Why don't a court just give judgment the following day? And then issues certificate, and the other one should be sworn immediately. What kind of? And is Nigeria a banana republic? There should be a grace, even apart from the sitting governor filing a stay of execution. There should be a grace for even a week for the governor to appeal. I think it should be in the constitution. People like Uban in Lagos here, and one lawyer, saying that they should swear in the man quickly. And one of my good friends also in Abuja, Mr. West Okereke, everybody is saying they should, the man should leave the seat. And it's not war. There's war in Maiduguri and Niger Delta Avengers. This court we should obey the law. We should take it easy. Let this man file, and then let's give another 1 month. The man, the moment the court now says, no, the man is the present governor should vacate, then he should vacate. But we are not fighting war, please. The court, they should wait for another judgment from the court before the man vacates the seat. And the other man, somebody, Oga, he should hold on, please. Thank you, Mr. Ayode.
Indeed, thank you, Mr. Mahmood, for calling in. We've said before on the program this morning that when the law and politics collide, sometimes you have this kind of casualties. But the point being, now we're getting viewpoints that seem to be suggesting that was INEC a bit hasty?
Yes. Yes.
You know.
That's my position.
Yeah, okay.
Yes, INEC was hasty. Because now, even the federal government, to the best of my knowledge, does not believe in INEC's action. Why? If there is a proper, if INEC had taken the right action, which the federal government believes in, let me tell you what would have happened. You can hear me?
Yes, I can.
What would have happened is that withdrawal of DSS from Ikpazu, withdrawal of police, withdrawal of everybody.
That's what
he becomes a ordinary citizen.
Yes.
He won't even have access to government house.
Yes.
No, I'm just telling you.
That was the way some people looked at the judgment simplistically. This is what should have happened.
And that's if the federal government had believed in what INEC did.
Okay. So they might have caused that to happen.
Immediately, Ikpazu has no control over the withdrawal of DSS, withdrawal of the police. So some of these people, with due respect to them, who have varied different opinion, to the fact that immediately means that everything
and even now the Attorney General himself has said, take a chill pill. Take a chill pill. Well, Mr. West is also on the line. Good morning, Mr. West.
Good morning, Mr. Yori.
Thank you for calling in.
Good morning, Mr. Ricky.
Good morning, thank you.
Yes, I know your stance on a lot of issues like Saraki case and all this. But on this case, you are right. The INEC in law, because even 143 of the...
Oh dear, but he wanted to weigh in on the side of INEC was hasty. I think that was where he was going. He was going there. Well, again, these are matters that we can talk about here, but it will take a court to pronounce.
Sure.
It is a court who will say.
And when a matter is professional, I want to appeal to Nigerians to Google to do a research on it before they get an informed opinion.
Well, yeah, lawyers, okay. Lawyers should do research on it, but since judgments are not made for lawyers, judgments are made for society. Pronouncements are made for society, right? For the good order of society. So when an ordinary quote unquote unlearned person hears from a court, you take that as that is the legal fact as of now.
After hearing from a court, you also heard that an application for stay was filed and a notice of appeal. Why not Google, juxtapose them, and ask, are there exceptions to enforcement of a judgment?
Okay.
Or is it holistic, absolute in nature?
We ordinary Nigerians, sitting down in our pepper soup joint, Jeje, we begin to Google this
No,
whole
from
matter.
common sense.
From common sense?
From common
we
sense.
take the judge as
That-
common sense.
No, we do respect.
We take the judge as common sense.
Even though everything in life has exceptions.
All right, I agree with you. But I got to take Mr. George calling in from Ikeja. Mr. George, good morning. You're our last caller.
Good morning, Uncle Yori. Thank
Good morning,
you for
sir.
accepting my call.
Thank you.
With due respect to the lawyer there, Uncle Yori, I refuse to be on the same page with his argument. I have read the judgment, and the case in question, even though I'm not a lawyer, is criminal. It's not like he rigged an election or he's contesting figures about his election. It's about he committed a crime prior to that election. When you see the verdict that judge gave, I doubt if another judge that is thorough will even grant a stay of execution. He says he should be sworn in immediately. And my gentleman in front of you is rationalizing it, what is immediate or what is not immediate. Immediate means the closest possible time that the swearing in can be done, bearing in mind everything that needs to be done before that swearing in. That is what immediate means in this case.
I think
So it's not
everybody will be happy with that.
So what is the question of whether, are we saying that if we have been doing, he said we have the way things have been done in the past is sluggish. When something is supposed to, when a judgment is given, it is not normally implemented. How is that the right thing to be doing? Should we be in that mode forever? Are we not supposed to improve in what we do in this country? A judgment is a judgment. If it is to be implemented, I remember Mr. Udwagan of Delta State, when there was a judgment that he should vacate his office, he vacated, and another person was sworn in. Then he went back to correct what made the judgment to be against him, and he came back as governor.
Okay.
What is wrong in that?
All right, then. Thank you very much, Mr. George. We've completely used up our time now.
Mr. George has not cited that it was a high court that took the decision he's talking about. In 1985, in a criminal case, an armed robber was convicted. Sorry, I'm rounding up. An armed robber was convicted. While he was on appeal, Oyo State government executed him. The Supreme Court was very hard. All these armed robbers are waiting trial. Many of them are waiting trial because of appeals. So why is it that we don't go on executing them?
All right, then.
So we are attaching politics to this matter.
Well, as we said, it does get a bit complicated when the law meets with politics.
Sure.
But
Thank you very much.
Thank you very much, Chukwemeka Eze, for coming on and giving us the benefit of your perspective on this whole matter. Because what we're looking for really is to try and understand it. We've heard it from, as it were, Uche Oga's side. We're also hearing it from Okezie Ikpeazu's side. And this morning...
Luckily, I'm not from Abia.
Luckily, you're not from Abia and you're not for either
to say
side.
I'm taking sides.
And this morning in Abuja, the court will be determining whether it wants to grant a stay of execution, right? And then the whole matter of the substantive issue, I think, is further on in the month. Thank you very much for coming on.
Thank you.
I'll be back tomorrow, God willing, with a fresh edition of the program. I'm Yori Fulani. Bye-bye for now.